Welcome to Defense Diaries. I am your host, Bob Mata, and this is my beautiful, brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, y'all.
So welcome to day 3. There's been a little bit of a dispute as to what we're going to call this. Is it day 3 of trial? It is indeed. Even though the trial in earnest has not begun, the trial process has certainly begun. Today, we were in court. Allie broke her Delphi trial cherry today. She accompanied me into court, which was amazing. I loved it. It's wonderful. It made me wanting for more, though. I definitely want my wife sitting in on some of this trial with me. So we are here to discuss the people of the state of Indiana versus Richard Allen, who stands accused of the double homicide of 2 beautiful young ladies, Abigail Williams and Liberty German, ages 13 and 14, respectively, who went missing on February 13th of 2017 and were found in the late morning of February 14th of 2017. The investigation stalled over the course of 5 years. In October of 2022, a man named Richard Allen, the very man who is standing trial right now, was arrested, and a 2-year process, pretrial process, has taken place, which has been, if you've been following our coverage, has been very unusual, not your norm. And now here we are on the eve of opening statements. So tonight we want to give you guys a recap of what went on in court today. And it was interesting. It was interesting. Allie was the note taker, so she's going to be trying to decipher her cryptic writing for y'all so that we can let you know what happened in that courtroom. I know you guys saw probably lots of tweets. Andrea and Lawyer Lee probably have already gone live, but we all have different perceptions. It's probably worth watching all 3 of us because we're all going to give you different stuff. We all have different notes. Funny story to begin. Allie and I decided not to leave. Well, shouldn't say Allie and I. I forced Allie to let me sleep last night because it was so late. We wouldn't have gotten in till probably 2 a.m. So I said, look, why don't we sleep tonight? I'll get up early around 3 a.m. We'll drive. You can sleep while I drive. She's like, you're never going to make it because we do lose the hour, and that hour is big. So she was like, whatever, do it however you want. So I got up, got the car packed, waited till the last second to wake her up, which irritated the shit out of her. She wanted to be woken up I was trying to be considerate. So we get in the car, we make the drive, we make it to Delphi. Allen County by about 8:05, right, babe?
Yep.
So we parked.
We were in the building by 8:05.
Yeah, we park. I had hit up a couple of people to find out if there was a line issue. I didn't think there was going to be today. I thought that a lot of people would fall off. I thought a lot of people would start making their way on that 100-mile trek down to Delphi to Carroll County, which stood to be true. We had no problem getting in. There was tons of room in there. Tons of press was not there. Very few civilians, and it was basically there was, Allie and I and Andrea and Lawyer Lee were in there, and a couple other podcasters. But so Alice and I are in there at 8:30. I asked somebody, "When's this thing supposed to start? Is it supposed to go to 8:30 or 9?" And I asked a reporter, and the reporter's like, It's 9 o'clock start time." I'm like, "Perfect." I'm like, "Allie, let's go get some breakfast real quick or some coffee, something."
And
She's like,
I think I
"Okay."
was like, "Are you sure we can do this in enough time? What if they start early?"
Wait, you didn't say that. What if they started
I
early
did,
part,
and you
did you?
said she started on the dot, 9
She
AM
did. That's
time.
facts. That's absolute fact. She really did. She started right at 9 a.m. on Tuesday. So at any rate, we asked one of the uh, security down on the first floor of the courthouse. We're like, "Hey, where's a good spot to get breakfast?" It's right by the courthouse. They're like, "Oh, just cross the street, go down to the basement. It's good and it's cheap." So we run over there, order a couple of omelets, wet. We really want scrambles. She whips them up. They were delicious. We pound them down in 3 minutes. We get back, and judge is on the bench. There's a witness on the stand being questioned. Everyone's paying rapt attention. I'm like, "Oh my God, what happened?" Allie asks the guy next to us. She's like, when did they start? He says, "Yeah, like 20 minutes ago." So we missed the first 20 minutes. Lawyer Lee was kind enough to send us. Darren says I keep doing that clicking thing. You have to
That's right.
you have to stop me from doing that. I think I picked it up from the Karen Reed trial. There were so many like teeth
All right,
sucker
move
things.
on.
Swear to God, I've never done that in my entire life. So, which by the way, I scanned the first 3 pages of Lawyer Lee's notes. Do you want me to send them to you? Because we don't have anything. Would that be
Well, just
helpful?
start with who he was, and then I was there. We discussed our notes today. We talked to Andrea about what happened with the first witness, so we were pretty much on par once she got to
Well,
cognitive.
Andrea was late too. She missed the
I know
whole.
what I'm saying is Lee and I went over our notes with Andrea,
Oh,
and
okay.
her and it didn't seem like 20 minutes went by, or there might have been a lot of background, that wasn't necessary. So I'll tell you when I've got you. Just start with the guy's name and his
Okay, so there was only one witness who was called, and remember, this is the state's motion, so it was their burden.
to
So they called.
exclude. Sorry, it was their motion to exclude the composite sketches as evidence based on hearsay, that they're hearsay evidence and irrelevant.
Correct. So they end up calling a gentleman named Thomas Plantz. It looks like Plantz. He is a retired special agent with the FBI, I believe. He retired in 2024. He's got a Bachelor of Fine Arts. 1995, he joined the Indiana State Police. 2004, was with the FBI. He was a special agent and forensic artist. And then he was the first FBI agent qualified to do forensic art, which is interesting. Created over 400 images over his career. He's real big into this cognitive interview way of speaking to eyewitnesses in order to try to come up with these composite sketches. He kind of goes through his entire process. He talks about how he brings in the witness and he really tries to build rapport for sometimes 2-3 hours. It's not like you see, he specifically testified, it's not like you see in a TV show where it's like, "All right, tell me what he looks," and like the artist is sketching as they're saying it. He says, "No, it's bigger or smaller, bigger ears, or his eyes close together." He's like, "That's not how it goes at all." There's a long interview process that takes place prior to, and then it's a collaborative, kind of a collaborative process between both the sketch artist and the witness. And they'll go through and he will ask questions like that as they're going through relative to, certain features of the face. So that part was kind of interesting. He talked about memory codes.
No, I think that's where, but go ahead, and then I think that's about where I pick up.
You sure not confusing the old cheat codes?
No,
Okay. Because cheat codes was a big thing. Cheat codes was the big gotcha moment with this witness from the defense's perspective. So the memory codes are formed when you see something, uh, and then you're unpacking your memory and your memory codes, and he equated it to dominoes, saying that you're unpacking these memories, and you once you unpack one, it knocks the next one over, and so forth and so on. And there really isn't an unimportant detail in his mind. Anything that you can think of, anything that you can recall, he just lets them go. Like, he doesn't interrupt them. He's hoping for kind of a stream of consciousness type of deal. It's really kind of interesting to kind of learn the mechanics and how they do these sketches. He never interrupts them when they're going, in the hopes that more will come. He's just letting that person kind of recollect, and obviously things like duration from the time that the witness saw the potential suspect or the suspect to when that witness is teamed up with the sketch artist. I mean, if it's 4 months, memory is going to be fleeting. If it's 4 hours, memory is going to be strong. That obviously makes sense. And then, so I mean, do you think you're pretty much caught up with it from there?
Is she next going into the the background and the individual encoding stuff, or?
No, I think we still have a little more. So he says that factors that impart the witness's observations through memory are encoding, storing, and then
Retrieving.
You can retrieve them later.
Okay,
So environmental access. Do you have that?
yep, I've got all
Okay.
that.
All right.
So he kind of compared this whole cognitive interview as an open narrative, and the whole encoding. He said it was like a triangle, and at the top you have the open narrative, which is what he calls this cognitive interview, where they're talking about even sights, sounds, and I think Bob
Smells.
mentioned smells, right? All of it. And at the bottom he calls it like a human profiler builder. The communication, the more clear the communication is in his mind, the better. And he doesn't start drawing until after the cognitive interview. And he said that kind of multiple times. The cognitive interview is long. It's very long. You spend a lot of time with this, just talking with him, not interrupting, things like that. And then he said that the 3 stages of memory was the 1, encode it. And he was talking about how, like, if we all were in the courtroom and saw lights fell from a ceiling, we would all encode it sort of differently. And then where you store it, he compared it to a filing cabinet. Now, I don't know if you guys have heard of this filing cabinet memory. I'm drawing a blank on what they call it. Maybe it is just that. But I tried it last year because I have a horrible memory. So, and they had said how to do it was like, you picture something and then like you put it in a place in a room, like for instance in your house, like where, so I used like my parents' bedroom growing up, and I took all the baseball players because I like to watch baseball with Bob. And I was like, all right, I'm going to know all the players. I'm going to know where they're at, and this is how I'm going to test this filing cabinet memory thing.
She really just like Paul Konerko. I think she had a massive crush on Paulie.
No, that was in like 2001. I'm talking a couple years back. I tried this, and it worked for a little while, but there's no way, even if I think of my parents' room, and which, like, I was like, it was stuff like, put this player under the bed, put this player, like you put them in different places, and then you were supposed to be able to kind of think of the room and recall it. Whatever. That story has nothing to do with this guy's testimony.
Did it work? I'm dying to know.
I'm saying for a little, but like later, like now, I can't.
Stick.
Right.
Okay. Oh, and by the way, before you continue, I just wanted to let you guys know, Stacy Diener was the one who handled this motion for the state. It was the first that we had heard of her because Nick McClelland, as we told you yesterday, took control and was the only one who did any of the voir dire. So, and I'm not going to go back into that, but I thought strategically that was a weird decision. But so Stacy Diener handled this for the state.
So then he talked about how people encode their memories and that every individual does it differently. And it's based on all sorts of individualized factors: education, background, race, trauma, everything, all your life experiences. And he also said, like, if you were hungry or tired or stressed, like you have a divorce pending, all affect how you encode it, where you store it, and how you retrieve it. He also talked about how, like, a victim versus a witness. So the person who's going to have the most information is someone who was traumatized. Not only do they have that extra time, I think he said it was a violent.
You didn't hook your mic. I can tell you're definitely. You keep talking.
A violent
I'll handle your
assault. Bob's trying to fix my
you're
sound.
Oh, you are on it.
Yeah, maybe I just don't have it turned up high enough.
No, you don't have to have it close enough. Huh.
All right. Hopefully that's better, guys.
Okay.
But I didn't have the chat on, so I wasn't seeing.
No, I didn't try to tell you in chat. Just tell it. So.
No, I mean, but if people were telling me, I'm going to put the chat on just in case everyone's like, you're really loud now. So like people who were violently assaulted and get like the fight or flight, they imprint the information more because it's very significant in their life, as opposed to a witness with incidental contact for just a little bit of time that it's not real significant. And I think the point of them bringing that up is because that's what all of these witnesses were: people who just passed a random guy and had no reason to give it much of a second thought. He says that the police give him a brief description of what's going on. He wants it to be short because he doesn't want to be influenced. I mean, he really paints a picture of how the less he knows, the better. He can't be influenced by it. That this is really him, his sketch as much as it is the witnesses. He said that when the interview is like going on during the cognitive interview, he determines whether it's going to be beneficial to make the sketch. Like he said, there was only one time in his career where he could tell after the cognitive interview that the person didn't have enough information to really put forth any sort of sketch. And now I wrote here that I felt the state was kind of leading him, trying to get him to talk about. She's like, well, what about a witness who really only saw the person for a short period of time and there was something obstructing their face? How do you work around that? And he kind of gives the same information about how he does this all through the cognitive interview. And he can tell from the cognitive interview whether the person is able to recall enough for him to start sketching. And she says, again, she gives another like, well, but what if they're just not really able to give much? And he gives the same answer again, that he starts drawing, and then if they realize that they can't do it or that it's not going to be productive, then they don't do a composite sketch. Here they did. One of the things that Bob and I both talked about that we kind of thought was odd is like how the state is now again flamethrowing in another entire science that they use for investigation and at trial, all the time, because they use, like, well, you saw the person and you drew a sketch and then this person was found. Like, even if the sketch doesn't come in, they're talking about how reliable, these sketches are. But here they just kept trying to push that it's all subjective. And then they really doubled down on it. They called it double up on subjectiveness um, with any forensic artist, because it's subjective to the witness. It all, again, the way they code it, the way they store it, that whole subjective thing, and that all these factors change the way people do those things, and also his subjectiveness, his life experience, his this, his that. So he said that was for I underlined, forensic artist, and basically any police interview at all. He says a composite drawing is essentially just an illustration of an interview. That's all it is. So, and when you think about it like that, it makes sense. He's saying that they use the same police techniques, so in the same sense that he's openly saying how it's like double subjectiveness when they draw these sketches, it's double subjectiveness when an officer writes down somebody's statement. That's why Bob and I are always talking about how we want to listen to the recording, because you would not believe how many times when you listen to the recording, you're like, that's not what this guy was saying. So they kept hammering home the subjective nature of a composite sketch in general. He talked about how he would, ask clarifying questions. Like when you get to age, you never say to someone, how old is he? Because the word old puts that thought in their mind of old. So it would just be, can you estimate the age? Can you estimate the height? Because I guess you would say, if you say, how tall is he, that you're suggesting the person is tall. Talked about how it's hard over different across demographics is harder. So if you ask a 17-year-old, can you estimate the age? Oh, he was really old. I mean, really old. And then when you push, it's like, oh yeah, 30, really old, that kind of thing. He said that it happens in the reverse too, older people to younger people, women to men, things like that. It's also subjective because it's based on the skill of the artist and the interviewing skill and artistic skill um, of the interviewer / artist.
Which he said that a lot of artists or forensics have one of the talents but not the other, and that it's rare for that you really do get a really good forensic artist if they're good at both the interviewing process in addition to being a good artist. And the one thing that he said that I found interesting, and I don't even know if you found it interesting enough to write a note about it, was that when he does his sketches, he's like, I can absolutely draw and sketch to
Mhm.
make something look like a photograph, but by choice, I purposefully want it to look like a sketch. So, which was an interesting concept, because you've seen people that can draw to where it's like, wow, that almost looks like a photograph. And that's really for the public, he said, in terms of that being distributed out
Yep, and
because
I did get to that. We're just not there yet, but I also did write that down.
yeah, and I mean, the reason that he does it is because he doesn't want the public to think that this is exactly what the person looks like. This is
Right.
supposed to
It's an
be
estimate, he called it, an
an
estimate.
estimate, a
Supposed to
clue.
see it and trigger your mind. So he
Right.
said, like, once the cognitive flow gets going from the interview, um, people start to remember more, and various things can trigger memories, a smell, something. Um, Other ways that he can know that he is getting a productive sketch. He says, like at the end, how they react. He said he's had victims of violence just like puke, like get really sick when they see the image because they're so struck by how it looks like the person who victimized them. And then he says about he uses a scale from 1 to 10. 1 looks nothing like them, 10 looks exactly like them. And he says about 3/4 of the way through from when he's drawing, he starts to ask about the scale. And if it's a low number, he'll keep going. If it stays low, that's one of the ways he knows it's not working. But if it for instance, if they went right to 10 right away, in his mind, he said he has never gotten a 10. And that's kind of where he starts to get into what Bob was saying. But this was important that he would say, all right, it can't be a 10 right away. So maybe he would probe people, like if they said something like that. But then as they keep going, he keeps asking again, like as he tweaks it a little more, what is it now, 1 or a 10? So if it goes up, a 6 and then an 8, and if it's not going up, then that's one of the ways he would know it wasn't being real productive. So then they get into how this is just an investigative tool. It's a lead generator. It is not used for identification. It's used for recognition. It helps law enforcement follow on a direction or investigate a lead. And then I wrote here that he's not supposed to be, the police aren't supposed to be out looking for someone that looks like the sketch. It's just to focus on suspects. Then he talked about whether he releases the sketch to the public. It's not up to him. It's up to the police. And then I wrote down he records cognitive interview. And then in my notes, I wrote, I get the sense he actually records it. It doesn't be, and then I also wrote to myself, like, it's not like he can really take notes during the drawing portion. So I got the sense that he actually recorded it. I don't know if that's something that the defense has or that they've asked for. But that was just my subjective opinion based on the fact that he said he records the cognitive interview. And then he did mention something about taking details in his notes. But I personally got the sense that he probably actually recorded them. But, and then when he gives the, if he knows they're going to use it, release it to the public, he gives a statement, and the state called it a disclaimer, that it is an approximation of appearance. Like, it's not supposed to be what the person actually looks like. The and this is when he got into how he intentionally draws the sketch to look very sketchy. He doesn't want it to look realistic, so that it's just an investigative tool that points to someone. And then the state got into, well, is part of the reason, like, that you wouldn't want to show it to the jury, that it's dangerous because it's going to imprint a picture on their mind. Like, if they see the image, they're going to be expecting a defendant that looks like that, so that it's dangerous. And then he said the words that it's very confusing to a jury if you do that, which is the key terms. When you're dealing with evidence, one way to keep it out is that it's confusing to the trier of fact, that it has so it's more prejudicial than probative, as we call that in the law. Then the defense got up and started doing their questioning. What's the lawyer's name that handled it?
Andrew Baldwin.
No.
Oh, Brad oh, no. OJ handled it.
Right. Okay.
So it was the two female attorneys on both teams handled the hearing.
So she starts out with, it's important to obtain an unbiased, uninfluenced sketch. Yes. Uncontaminated. Yes.
What did you think of Diener? That was the first.
I thought she did a fine job. Like I said, there was a couple of places where I thought that she was leading. But I don't know. What did you think?
I thought she was good. I was impressed with her when I saw her. I can't remember if she did 1 or 2 of the motions on the 3 days of motions, but I thought she performed well there as well. That's why I was surprised that Nick wasn't giving up some of the power and control in terms of letting the other attorneys handle some of these things. So, or at least the voir dire. But yeah, I thought she did well.
Yeah. So then she sort of went through that again, like, you don't want to contaminate it. And he's like, what are you saying? She's like, contaminated. He was like, oh, no, you don't. like looking at a picture, she says. And he was like, oh my God, that is the worst. That would be the quote highest level of bias. He would never show a picture. I'm trying to look. You wrote something here, and
I
he
did.
did. Oh, okay, yeah. So then she starts to get into, well, you did the sketch of uh, for Sarah Carbal. Is that the print correct?
Carbal. Carbal. Sarah Carbal.
Okay. So she gets into that, and then she sort of circled back, like with the showing the picture to someone could be so bad that you'd like arrest the wrong person, convict the wrong person. Yes, 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 it would be awful. The whole show, if the person he's doing the sketch with was to see a picture.
Did you write down the acronym of the, because there's guidelines from a couple of different places that she was citing.
Yeah, I don't think I wrote down the acronym, but sorry. So she gets into how there was one witness, and this was the witness who did the first sketch, was about 4 months and 6 days after she saw the person on the bridge. But it was the first sketch released. And that he had, oh, this is for Sarah. Sorry, right. So, and that he had never spoken to her before. And he agreed that he had never spoken to her before. And she was like, all right, within 4 minutes of speaking to Sarah. And then she was like, and wait a minute, let me just clear up. You had never spoken to her before. And he was like, no. And she's like, so within 4 minutes of talking to her, objection. And I wrote here, star underline under the state hiding facts, because I was like, what the hell are they objecting to like this? And the
And
state,
just as a quick side note, I apologize for interrupting you. So when you sit in a courtroom with Allison, or if you're watching a trial, especially live, including with me as her trial partner, she cannot help herself from calling out when lawyers should be objecting, when she smells that something, so she's like, leading. So like, and I'm
I
like,
don't think anyone else heard me.
oh my God, the whole courtroom heard you. The whole
Oh
thing.
no,
Up.
stop. So the state argued this is not about a specific sketch. It's about all the sketches. And the defense is like, well, this is one of the sketches he did. It's encompassed in all the sketches. And I think I have the right to, bring out how he handled this sketch and what went down. We've got to address each of the sketches involved. And then she's like, state, and the state's like, no, this argument is that no sketch at any point, none of the sketches can ever go in, period. It doesn't matter about the details of any sketch. And the judge sustained it. And then the lawyer for the defense was like, wait, what? Because she wasn't sure she really said sustained. And the judge is like, sustained, meaning she's agreeing with the state, and did not allow any of that questioning. But I can tell you what was clear to me, what it seemed like she was saying was, you went through this whole thing about how long the cognitive interview is, how important the cognitive interview is, how you don't interrupt them and you get a free flowing thought. And it's so important to do all of the steps beforehand, but within 4 minutes. So I'm just, again, and this is an assumption, that he started drawing within 4 minutes, or did something relative to that interrupted this free flow thing where he doesn't ask any questions.
The stream of consciousness. Let me throw an aside in there. There's an aside in the back in a backdrop or background that I want to throw in real quickly. So before Auger went and handled the cross, judge said, whoa, stop, hold it, wait, the jury's ready. So she called the jury in and they swore in the jury. I think that happened around 10. So the jury was officially sworn in, ready to rock and roll. And then with respect to Sarah Carbal, it was a very long period of time between when
4
she
months, 6 days.
4 months, 6 days.
Yep.
Yeah. So because when he gets over to Betsy Blair, it's 4 days. So there's a massive difference in terms of the ability to recollect. And Diener kind of, and I didn't hear you talk about it in the notes, but it's one of the things that I always talk about in our lives with respect to our memories is that situation wherein you see something and it may not be something of note. And you, at the time that you see it, have no idea that you should be trying to remember it. So it's one thing if you see, some bank robbers running out of a bank, you're like, oh shit, I got to try to remember, like, what does that guy look like? What is the license plate for that car? What are they driving? You're really trying to commit it to memory. Whereas, say, for instance, you have all these witnesses who at the time really had no idea that anything that they were seeing that day was of consequence. So it's a different recollection process, which is really, really fascinating and really goes to, like, I was trying to think, I was gonna quiz you, babe, like when they were talking about that, to see if you could remember what the security guard down at the bottom looked like, who told us where to go for breakfast, like the
I think he
details.
was an older gentleman with gray hair.
Did he have glasses?
I think so.
It's pretty good. Did he have a mustache and beard?
He might have had a mustache.
What color was his jacket?
Burgundy.
Wow. Pretty good for somebody
I
who
thought
complains.
that was like that's in my mind is often like a clerky colored jacket. So I wasn't sure if I was making that up by going with like what's
Yeah,
in
it's
my mind.
typically a burgundy or like an ugly mustard type color.
Right, something.
But no, I mean, that was a really good job because I was thinking about it then. So I kind of committed what he looked like to memory because I was trying to kind of test that concept. But, it's just one of those things. Now, if I asked you 2 weeks from now, you'd be like, I have no idea what that guy looked like.
You know
who
what I think it was? We went back and talked to him afterwards. And then I went back at lunch to see if he was going to suggest something. So I looked for him. So I think I must have like pulled the memory, even though it wasn't like a conscious thing. Because I was surprised. I remember too.
It's a good job. Good job.
And then I wrote in my notes, how does each witness's scale not relevant? He just went through like the whole scaling thing. So if part of it was like they were saying it was unreliable because it's so subjective, and when there's more people involved in a sketch, it's even more subjective. Well, what if he told us what each person's scale was? How long did it take this person? Like, I just couldn't understand why the judge thought none of that was relevant, except for the fact that she's likely just going to grant it just because the state asked. But then she got into, I just wrote standards and best practices. I didn't write which agency it is. And then I wrote, and she talked about how it's common to use a sketch as evidence. And he was like, I don't really think so. And then she went into how they have a signature line, and the best practices say the purpose to have them sign is so that it can be used in a court of law. And she pressed him a little more like, well, you do know that these get used in courts of law. And he's like, yeah, I mean, I guess, yeah. But it was like pulling teeth. Then Baldwin comes over and talks to her, like walks up to her. They have a little convo. She goes back.
Confab.
And she says, is it always important to use best practices? Yes, but you have to adapt. So I'm like, all right, so he's building up for he didn't use these best practices somewhere, take you a minute before.
And one of the other things that I thought was significant, which you touched upon and kind of like abandoned the train of thought in terms of this is the second time in recent memory that we've seen the state of Indiana in this trial flamethrow would have been massively important tools for them, especially the sketch artist stuff. The composite sketches have been used forever, forever. And so
Right.
they flamethrowed that and
And
other
geofencing.
in the geofencing. So where they've essentially made them unusable in terms of any future criminal cases because again, people will be able to pull the transcripts of sworn testimony from this trial and say, "Oh, well, you're saying that people should rely on composite sketches or that they're a reliable way of identification." Uh, and you're going to be
Tools
able to
right now.
flamethrow them, right? So they were very, very clear about saying it's just a tool. It's just a tool. They're never used for identification. They're used for recognition. And then that tool, if somebody says, "Well, I kind of recognize that person. It might be this person." From that spurs on the investigation. They'll go see if that person will be willing to talk to them. They'll try to have an interview with them. They'll dig into them a bit, but so they were really, it's an interesting thing conceptually as to why the state is trying to keep these things out, adamantly trying to keep these composites out. Now, I would argue that it's twofold. One, neither one of the photographs or the sketches rather look anything like Richard Allen. Now we had lunch with Andrea and Lee, and Lee's like, "Oh," she's like, I think the July 17 sketch is a like dead ringer for Rick Allen. I'm like, "What?"
So I'm waiting, and on that, I'm waiting to get a picture of what he, a good picture of what he looked like around that time, so I can look at it. But yeah, and I definitely agree that was that was odd.
And the other reason why they want to get rid of it, as I said, it was twofold, was the fact that remember in Indiana, lawyers can depose witnesses prior to trial. Allison and I do not have that advantage to being able to question people under oath prior to trial. We have to fly blind, but for whatever reports exist, police reports, if they've made a statement, recorded or otherwise, we have those, but that's it. We don't get to question them in Illinois. Here they do. So we know that Baldwin and Rosie have done at least 70 depositions since they got back in whenever it was, January of 23. So they have done like I want you to try to imagine how much work that is in comparison. What came out today, which I thought was stunning, was that the state, because that's discovery in Indiana, that is critical discovery to have that advantage to be able to ask questions as a defense attorney where you're never in the position or you shouldn't be in the position of having to make the fatal flaw of cross-examination, which is to ask a question that you don't know the answer to. You should know all the answers to all the questions that you want to ask because of the deposition. And that's notwithstanding the ability to be able to impeach somebody because depositions are sworn testimony, but having that advantage. So the point being here is that Baldwin and Rosie had the ability to be able to ask these eyewitnesses. So is Rick Allen the guy you saw on the bridge? And they know what the answer is at this point. And you know who else knows who the answer is? Because when they arrested Rick Allen, law enforcement asked them, they probably went with the six pack and said, "Look, this is the guy we arrested, or we arrested somebody. Do you see him in this photo array of six people?" And none of them identified Richard Allen. So far as that they are not even listed on the state's witness list, which blows my mind. I mean, think back to the probable cause affidavit. Okay, we had
I
Richard
think that
Allen.
they said the words they kept saying is, "We're not calling these witnesses for identification purposes. I don't know that they're not
sworn. Maybe I'm wrong. Maybe I'm wrong, because they whipped through the witness list. They were just reading them like one after another, rapid fire style. I do not remember hearing the state naming Carbal or Blair in their witness list. Maybe I'm wrong. Like, do not hold me to that. I could
Right,
be
I
way
wasn't
off
there.
on that,
Wasn't
but
there.
I know for a fact that they're on the defense's
Right.
witness. So,
Right.
but I mean, they've got witnesses that can't say that Richard Allen was the guy that they saw that day. So they don't want anything coming in that is going to additionally hurt them in terms of none of these people are fingering Richard Allen. So in their minds, they feel that because when you get down to the brass tacks, which Allison's going to get into, of the argument as to why the legal grounds by which they think that the things should not be admissible, the reality is that, and a third thing is that you now have Jerry Holman standing on his testimony again under oath, wherein he said that the 2019 and the 2017 sketches on the stand in late July are the same person, which is absurd, because when Baldwin back in July and early August tried to play the Holman press conference, wherein Jerry Holman says, no, we like forget about July 2017 sketch. We've talked to that guy. We've cleared that guy. 2019, that's Bridge guy. So Holman, like you can imagine what that impeachment would be like at trial. She would not, she being Gull, would not let Baldwin play that press conference video during the hearings, which theoretically means that she would not let him play it at trial as well, which is, I couldn't see the rationale behind it. I just couldn't. I like, it was another one of her befuddling
I don't know
decisions.
how she's going to prevent the defense from um, challenging the integrity of the investigation and what leads they were following and when they decided to follow them, and that you turned away from this first image, the one that you're now saying, whatever. I guess now he's trying to say both images are sketches or Richard Allen. When we were at lunch, we were all like, well, we all have eyes. We can see that second sketch, and no matter what world you are from, could not, looks nothing like Richard Allen. It's someone significantly
22-year-old fresh
younger.
baby.
But the point being, the judge should not be able to prohibit the defense from challenging the investigation. You sort of saw that in the Karen Reed trial, even when they wouldn't allow certain third-party third-party culprit evidence, she still allowed them to challenge the investigation with that same type of questioning and line of questioning. So now I'm going to go back to the line of questioning after the convo with Baldwin, but I want to mention, up to this point, I just kind of felt like, oh, this witness seems like he's very truthful and he's forthcoming, and kind of weird that he's going to allow them to flame throw his entire profession. And I was also thinking, they've talked about this beforehand and he knows what they want to say, but I still just felt like generally he seemed like an honest kind of guy.
Yeah, I got the same impression.
So then she starts to ask the questions about, well, you're going to follow all the best practices. And he's like, well, yeah, but you have to adapt. And she's like, but you're definitely going to take that time before the interview, before you start drawing. You said that was important. Yes. You wouldn't tell a person it's okay to cheat. And he said, well, I use the term cheat code. And now at this point, I'm thinking that maybe the defense is being disingenuous and he used cheat code. And now they're trying to make it sound like he was saying cheating. And I actually turned to Bob after he explained it again, that, I've used the words cheat code, like, how they use cheat code. And I was like, they're showing their age. Like, they don't know what, like, I'm like, this is a generational thing. They don't know what cheat codes are.
He's never heard of Black Thought. You know, I mean,
Right.
come on, man. It's like as soon as we got in the car, I played a sweet little song from Black Thougt's album from 2 years ago called Cheat Codes, which, you know, I was like, "Here, I'm playing this
So
for you."
anyway, yes.
That
So
was the
anyway,
aside.
she wants to, then the defense goes to move in Exhibit A, which is a picture of him interviewing Sarah, and she starts to ask some questions about that. And then she wants to admit the it's a recording, so she wants to admit and play the audio. And the judge like turns to the state, like, state, do you have an objection? And the state says no. And I wrote with a star, the judge begrudgingly admits without objection, like she wanted them to object. So they start to play it, right? And it says, he asks her, you know, if she had seen the picture, the image of the bridge guy, and she says yes. And oh, and before they play it, I'm sorry, before they play it, damn it, the lawyer asks, "Well, you would never cheat by showing her a picture." He's like, "No." Um, and you know, you wouldn't want to trigger what she saw, and he's like, "Absolutely not." Um, and then they play this, you know, video, and he's asking her the audio. He's asking her if she had seen the picture, and she says yes. And he says, well, you know, it's all right, you know, we can cheat. I'm going to show you the picture. So he shows her the picture and gets the picture of bridge guy. And he is arguing that, well, that's different because you can't see his face, and so that's not cheating, that's not showing a picture. Well, meanwhile, what I think we would all agree on is primarily it's not like the details of the face, it's the color of the jacket, what he was wearing, the facial hair, like essentially eh, what I take it to mean now is that first sketch is really a sketch of the image of bridge guy, a literal sketch of the actual image, with them, you know, trying to clear up some of the facial features. So, you know, he tried to walk himself back from that and say that they even allow you to use like a surveillance video if the face isn't on it. But in this case, I find it significant because it's sort of all of those other things is what they've kind of been using. She saw the blue jacket, she saw these jeans, she saw, you know, and again, the hat and the facial hair. It wasn't so much the actual structure um, of the face. So then they end it there, and on redirect, um, she focuses on one of the points that they had made on cross was that uh, the best practices indicate that the sketch is to be retained as evidence. So the state made a point. Well, just because the best practice is to keep the sketch as evidence, that doesn't mean it's admissible, right? And he's like, no, which is, I would say, a fair argument that the state made. Like, when the rule says keep it as evidence, doesn't mean it's admissible. That in and of itself doesn't mean it's admissible. Um, And then she got back up and did another recross, two questions. One, the best practices say a signature allows the person to identify, quote, in court, yes. And two, you said we can cheat, and showed the picture. That's the words you used. And he said yes. Um, and um, then they introduced the Betsy Blair deposition, and the fact that she said that the man on the bridge was a 10 out of 10 is what they argued. Um, and that routinely in Indiana, they admit sketches, and she gave a couple of cases where they had admitted sketches. She talked about how there's also some more recent case law where they talked about how people who were hypnotized, their sketches weren't allowed in if their sketches were produced through hypnosis, which tells you that Indiana allows sketches when it's not through hypnosis. And then the
I
state,
thought an interesting thing, Al, was the fact, like, conceptually, when you hear the state referring to composite sketches as hearsay, when you kind of hear the context of which how this sketch artist, his process, you realize that really this sketch that you're looking at is built from a bunch of out of court statements made by a witness. It really kind of helps solidify the concept of why it can be considered hearsay, because it is out of court statements. Now, whether it's being offered for the truth of the matter asserted is an entirely different question, and you need both those elements for it to be considered hearsay. But I thought that was interesting, because you and I were like, when I told you about this motion initially a couple days ago, you're like, well, it is hearsay. And I'm like, yeah, I guess it is. And I mean,
right,
it
but
is,
that there were
you know,
ways to work around it, because here at the end of the day, and then let me just say what the state's response was to that, and then we'll move on. And I mean, then I'll circle back to this. Okay, so then the state argued that the one case that the defense relied on, where the court specifically said that they adopted it in court, so it wasn't hearsay. And when you have a statement that somebody signs and attests to and testifies to, a written statement, those are non-hearsay. So the whole signature line, and if she were to adopt it in court, they could get around the hearsay. And they said, well, that was before, it was like 1974, before we had our rules. And also the defense said that they wanted Sarah's excluded, that they agreed with the state as to Sarah's, because that's the
right.
one that the older one where it looks more like Richard Allen. The state argued the persons who identified Bridge Guy are not being called for identification purposes. So I don't know if it was called, period. She argued that it might imprint the jury by giving them the sketch, that she didn't want it to take place in opening. And they asked the court to rule that all the sketches are hearsay, actually double hearsay, and that, that there's no exception under the current rules of evidence, and it's not used for identification. It's supposed to be used as a tool, that whole argument, and that it's not being offered to identify Richard Allen. So it's irrelevant, double hearsay, and overly subjective. So that's she kind of circled back and said that a couple times more. The defense argued Rule 803 D1C that says that a statement is non-hearsay, that a sketch is non-hearsay when it's shortly after they have observed it. And she said that Blair was 3 days later, and that it's still relevant, even though they're not using the sketch to identify Richard Allen. And then again, I wrote in my notes, it's clear that first sketch is literally a sketch of the image reflected on the video. And then basically the judge said that she's struggling to see how it's relevant, but she's going to take it under advisement. But basically she was struggling to see how it's relevant. Now, at the end of the day, this is my opinion on this. This is not going to be one of the things that changes the trial, that allows an appeal issue, or this is going to get reversed just for this reason. You can get around all of this. You put Betsy Blair on the stand and you say, did you see a person and this is what they look like? And you went to, and you did a sketch with someone and you felt 10 out of 10 that the sketch looked identical to the person. You still feel that. Did that person look anything like Richard Allen?
Right.
Did he have any face? He was much younger. You know, he didn't have any facial hair. You're certain that person looked nothing like Richard Allen. And you remember your sketch, right? Yeah. And that didn't look anything like Richard Allen, you know? So they don't need to put in the physical sketch, although I understand why, you know, why they would want to do it.
Yeah. I mean, to me, it's disingenuous. You know, the fact of the matter is that they're acting as if that was not one of the primary tools that they used to try to find a suspect in this case, you know, and frankly, I just, it doesn't sit well with me, but the reality is that you and I talked about it. I think that the fact that Carbal and Blair are both going to be there in person to testify. And I think that their testimony is going to moot out the issue. But in order to just kind of keep hammering away at this investigation, I think that it's more of an important piece of that puzzle, that the things that they did and did so poorly that they don't even want these. Like, I want them to be shown by the defense just so they can say that the state didn't want to show you these composites. You know, like it's just, to me, it's one of the bricks that they can like use to build this building of, this was a shit investigation. For this is merely one of the many bricks. And, you know, so I think from that perspective, it hurts a little, but at the end of the day, I agree with you completely. I don't think that it's going to have any, it's not a death knell if she rules against them, which I anticipate that she will.
Right.
So,
And I think that it's different if we get, if Betsy Blair gets on the stand and she's like, I can't remember, she could, you know, refresh her recollection with it. If she testifies contrary, she can impeach them with it. Then it's not hearsay and it's impeachment. I mean, I think that the judge would have to leave it open for, you know, for that to come in. After that, they talked about, you know, letting the witnesses in, letting the state asked to have two people to stay in the courtroom, Holman and is it Mullins, that they do different things. And, you know, she granted it over the defense objection that both people should go in. I mean,
and they had granted the defense's motion so that Max could sit in. They're young. I think it's Rosie's young. It's not even an attorney. I think he's still in college, but he's the kid who's going to be sitting there digging through bankers' boxes looking for exhibits, and you know he's going to be kind of the right hand man to everybody at the table when they need something. They're going to be saying, "Hey, Max, I need this." It's like we talked about this with Shannon Smith, and when she tried the Crumbly case alone, that like the concept of trying to dig through mountains, 15 terabytes, which is the equivalent of 15 terabytes of evidence to try to get the shit that you need for each individual witness is a massive, massive task. And I don't see how any attorney does it alone. So the defense got their guy, state got their two guys.
right.
You know, I mean, it's kind of like having two cops, the difference being that Max is going to testify to something relating to a prison visit at Westville. And you're talking about Jerry Holman, who was integral in terms of the investigation, who gets to sit in and listen to all the testimony and can tailor what he's saying because he's hearing all the other cops that testify before him. I mean, if McClelland's smart, he's putting everybody else on the stand before he puts Holman on, because Holman has the advantage of not being sequestered. He's not being separated from the other witnesses. He's going to sit in there and hear everything. I mean, that's always the point. That's why we as attorneys always ask for sequestration of witnesses, because we don't want them tailoring what they're saying based on what they're hearing other witnesses say. So it's kind of a big deal. You know, like, I mean, frankly, I think it's bullshit. I think Mullins was enough. You know, I mean, like, look, how many times have we had cops sitting at the table? I've never seen them instrumental to the
No,
state. Like, I don't never even they've never even talked to them. Well, like,
no,
I've never see them consulting with the cop ever, like in
no.
any of our cases. So I don't know. Whatever.
So the next motion was the defense's motion in Lemonade to bar the state from presenting the prison guards, inmates, and police who spoke to Allen or who Allen made statements to um, by putting them on to basically say that he wasn't acting insane when I talked to him. They were arguing that it would be, that they're not experts and they shouldn't be allowed to do that. And that he talked about how when they were interviewing people, they'd say things like, I know you're not a psychologist, but do you think he was faking? And he says it's an attempt by the state to get.
Oh, is this the iPass motion trying to get the settlement in?
No, we're talking about them keeping the inmates, the inmates, prison guards, and police who interviewed the inmates and prison guards from being able to testify to whether they thought Richard
Oh,
Allen
right.
was faking it,
Right.
whether they thought he was really crazy, anything about his state of his mental health, his state of mind.
Let me interrupt because there was a disconnect.
I'm
McClellan
going to
was
get to
talking,
it.
well, I mean, between McClellan and Rosie, they were talking about two different things. Well,
No,
McClellan was, yeah, they were.
right.
Rosie was, yeah. All right. Well, I was trying to spit it out. I'm allowed to talk during the live.
No, I know you are, but I still think that you got that. I think you got that mixed up because
I don't
the
think
way. So what Bob's talking about is Rosie said something like he can't put these people on the stand to say, he made this statement and was he faking it? Was his statement a lie? And at first I was like that. Like I leaned into Bob and I'm like, what? I thought they were arguing that he can't say he was like faking crazy. So then I felt he circled it back and he explained if you put the person on the stand at the same time he's talking about, this is the statement he made. He said to me, I'm going to make something up. I killed the girls and, you know, I had a knife and I killed them and whatever it is. And then in the next breath, they're going to be talking about how they thought that he was faking and lying and putting on a sham about his mental health, that you could not separate the two, that the jury, it would be confusing to the jury because they would take that to mean you thought he was, you thought that what he was saying was like that it would go to what he was saying instead of his actual behavior. Like either that or he tried to circle it back and change it around afterwards, but he said there's like no way to separate the two
Well,
when they're
Rosie
talking
said
about
that. Rosie
right.
understood the concept. What I'm saying, the disconnect is that Nick didn't understand what Brad was saying. Like because that's exactly what Brad was saying. Brad was saying they're intertwined. You can't separate the two. They're not mutually exclusive. And Nick just kept trying to say, well, we're like all we're going to put them on is to their observations, what they saw, and then ultimately, whether or not they thought he was, based on their years of experience and, them dealing with inmates with mental illness, whether or not what he was saying was true or whether he was full of shit,
Well,
and it
no, he
wasn't like,
specifically said, it's not the veracity of the statement, it was his behavior, whether his behavior was genuine, not the veracity of his statement, is what
it,
that.
what's the difference?
Well, what McClellan is arguing is that he's going to say basically, which is what the judge ultimately said, was that they can testify to what was said to them. They can testify to what they observed him doing, what behaviors he was doing. And then if the state can lay the proper foundation based on the amount of time they spent with Alan, the amount of time they were able to perceive him and what his perceptions were, coupled with their background skill and knowledge, that then they could say whether or not they felt he was, you know, faking his
See, if they would just use the right words instead of faking or lying, and just use fucking malingering. Because
right?
malingering isn't lying. Malingering is where you're faking an illness, whether it be a physical
Right.
manifestation of sickness or mental illness, whatever the case may be.
I wish
They're
they would
trying
have
to be
used malingering
fucking
as
nuts
well.
that they won't do that, because I
Then
think
you
it
wouldn't
got
have had that
lost.
disconnect.
Right. And I don't know that Gull got it. There were two things that she whiffed on that she just wasn't understanding. When we get to the I-pass motion, I guarantee you she was not understanding the fact that Rosie was trying to tell her, okay, well, you're telling me we can't mention the I-pass settlement, okay, which is relating to language that would be found, that would ultimately be adopted in the IODC, the Indiana Department of Corrections guidelines, where that describe serious mental illness. But what he kept trying to say to her, and she just wouldn't listen, is, what I'm trying to say to you is the actual in the guidelines. It physically says the words as stated in the I-pass settlement. This is serious. This is what constitutes. So she's saying he can't say it. She's saying, yeah, you can use the IODC guidelines, but you can't mention the I-pass settlement. And Rosie kept trying to say, look, I hear what you're saying, but what I'm trying to tell you is those words are physically in the guidelines. So if I'm trying to read verbatim the guidelines from the IDOC, which I'm allowed to use, I'm going to have to say those words unless you want me to say redacted or, you know, something weird. It's just like, it was two things that, because of that misuse of language, or the failure to use the term malingering, like, I just like, I don't know. I mean, she's gonna rule against them on everything. I think we all know this at this point. I mean, she gives that. It reminds me of, like, the, you know, the shit that we win, things that they can't, like, minute, like it's like minute victories. Like, they get max. You won the max motion, and you know, they won the motion that basically saves the court time, wherein they don't have to put on a day and a half of witnesses and evidence for the third party culprit offer of proof. You know, she incorporated that. You know, that she wasn't trying to do them any favors. She was trying to avoid them putting all that murderer's row of witnesses on again and taking a day and a half of trial time, which ultimately benefits the defense in the sense that they don't have to do it. Because remember, in an offer of proof, the jury's not in the room. You know, and I keep saying that there's going to be a lot of offers of proof on the defense side of this.
Yeah, for sure. They're going to have to put in additional stuff. So the fact that they don't have to repeat from before is helpful. So that's basically her ruling on the you know, whether they can testify about his mental health and their opinion on that. And then we moved on to the I-pass motion, where the state is asking to bar the defense from being able to introduce evidence about this I-pass settlement. And they were talking about how the evidence demonstrates that Richard Allen suffered from a severe mental illness, the way it's defined under IDOC, when he entered the IDOC, and he needed to be treated a special way. They were supposed to follow certain protocols about the way that they treated him, and that, you know, and that they didn't do that, and they put him in solitary confinement, and, you know, they needed to treat him a certain way, that they did not do any of that. And he wants to get into evidence how Richard Allen was treated by the IDOC, the definition of significant serious mental illness that came out of the I-pass settlement, and I forget what IPAS stands for, because in my mind I just kept thinking about like the tolls.
Holes,
Yeah. But he kept um he kept focusing on how they need to be able to explain to the jury how this whole settlement came about, so the jury can understand that the way he was treated has serious implications, so serious that it's like these are the type of concerns, the exact type of concerns that this entire settlement was, was about. And he being Rosie, oh good, we've got and Darren's going to kill me now, but Michael in here, so he may know some more about this as well. But you know,
it's the
Rosie was
Indiana Protection and Advocacy Services. That's what it stands for.
okay. All right. Um, uh, and then the and they changed the way what they consider to be a serious mental illness, and then the rules of how these people are, how inmates are supposed to be treated, and what they can do, things like that. Um, that the that when the defense argued that when Richard Allen, that it's relevant because when Richard Allen came in, the policy was, was in effect, and it's they've got to educate the jury on how it all came about. He focused on that.
I think at the end of the day, with the IPAS ruling, which she, I mean, I don't think we need to belabor this point. I mean, she said they can't bring it up. You and I kind of agreed. I think that it could have a real muddying the water effect on the jury. They'll be like, why in the hell are you talking about this weird lawsuit? Like, what does this have to do with the price of tea in China? But, because I don't think that they need it. Like, I
Right.
think
She argued, Judge Gull said, you can bring in the rule, you can tell them what the rule is, you can educate them and do all. I agree with everything that you're saying. You're just not doing it. You can do it through the IDOC rules, which define the serious mental illness and lay all of this out, but you can't do it through the IPAS settlement. So this is when Rosie's trying to explain. He says, well, are you saying I need to redact that portion out of the IDOC rules? And she kind of jumps back like, you don't have to redact anything. You're not using the IPAS, you're using the IDOC. And that's what Bob's talking. There was like this disconnect, because what Rosie was saying is, but it says in the actual IDOC rules, it references the fact that there's the history and the definition comes from the IPAS. And then she's like, I don't understand. Why would you have to use the IPAS settlement? And he kind of bit back and he said, I have to tell them the history of this, how this all came about. And that was sort of the end of that. She ruled that that he couldn't do that. And then there was the motion to exclude the defense's expert, the metallurgist, about the bullet. And this was the most important motion that was argued today. And it was at the only time at certain points where I actually saw Judge Gull seem to kind of pay a little bit of attention to what the defense was saying. And at the same time, she looked surprised at some of what the defense was saying about the science. And they started out talking about special knowledge about firearms, and the defense did that. I mean, the state started saying that this evidence isn't relevant. This guy he's never conducted any actual research on the bullets, and he's just a researcher of research. He researches research, is what the state argued, and that he doesn't have any special knowledge of firearms, that defense bears the burden of establishing the reliability of their expert, that it's going to be helpful. And they argued that it would be very confusing. I think Bob just, now my phone just died. All right, I'm just going to keep going, but Bob's checking on some of the neighbors here. I assume, and now my phone just died. But so then the defense got up. Give me 1 second. Sorry, guys. Hold on. Sorry, guys. You know that we are staying in one of the, darn it, why won't this fix? Why am I like that? Okay. That we're staying at the Airbnb of one of our very generous listeners, and there's an ambulance out front, so she's obviously worried that that's her parents, and Bob's checking, and they're talking about it. So I think it's okay. I think it's another neighbor, but Bob's in communication with them. So, and now there's an echo because I left the door open. Hold on. And I'm probably oversharing. So yeah, hopefully everything is fine. So then the defense introduced the CV. The judge spent a lot of time kind of looking at the CV. Like even when the defense was making some very important points, she seemed to me not to be listening and to be taking notes about the CV. But the CV sounded very impressive. And then they got into how the state has an expert in the same field as one of the defense experts, and that the defense expert acknowledged that all of the expertise that Dr. Tobin has are expertise that are important to the firearm science and analysis. They introduced his deposition, talked about how statistical backgrounds are important, and acknowledged that there is a debate, a very strong debate about the reliability of this type of firearm evidence, and that the critics, such as Mr. Tobin, have helped bring changes in the field, have advanced a lot of changes in the field, that they're sort of moving in the direction of a statistical probability type analysis, something different than what they're doing now, and that Tobin is one of those critics. They talked about the chemical process, how important it was, and that the expert acknowledged that everything good? Okay. So the metallurgy is a highly important science when it comes to the firearm analysis. It's something that's very useful, and they sort of went through all of that. Again, then they talked about how there's a healthy debate about whether or not firearm analysis, such as what the state's relying on here, should even be allowed in a courtroom. And there the judge makes a face. She's like, what? I mean, that's something all of us know. She seemed wholeheartedly surprised that science is at issue, and that courts and other scientists and expertise are challenging whether it's should be admissible. And then he focused on how it would be helpful to the jury. And this is where he gave 3 hypotheticals that I thought were very effective. And if you recall, when we were talking about the sketch artist, Bob was telling you how it was very useful. Like, he found it very interesting and helpful to learn the methodology of the expert. Like, why does he do this whole cognitive interview, and what's the reason for it and the steps for it? So he started with like a breathalyzer, and all right, it just you breathe in the thing and it just boots out an answer. You don't really, if you don't learn why, if you're not told why, well, what is it about the breath, and what is it that makes it trigger a number, and how is it being done? And he talked about a dog sniff. Like, okay, the dog sniffs. If the jury's not told how the dog is trained, what he's trained to sniff at, why he sniffs, what it means when he sits, what it means when he, like what his different cues are, then it's, how does the jury understand the significance? They're just supposed to accept the fact that, well, the dog sniffed. He sniffed it,
He alerted.
Right. He alerted without knowing how he was trained, what he's trained on, and what his different, different mannerisms mean, the different alerts, I guess, so to say. And then he talked about polygraphs. And before he got into polygraphs, he said, just as the state put on their expert to tell you how he goes through his process and what it all means, he used that as an example too, about how that was helpful to the judge in understanding whether these sketches are, should be admissible. So I thought he did a really good job of explaining why it's helpful. Like, here, the jury needs to understand what the science is, how it's imprinted, and how it works, so that they can make their own decision on whether what this expert is telling them makes any bit of sense, or is something that they feel is compelling or not. So that's why those are the analogies that he used with the judge about how it's, it's helpful to know.
Which I thought were very effective. I thought they
Right.
were a really nice way to kind of highlight the argument in terms of why it's relevant and why it's definitely admissible. To me, this motion in particular, more than any of them, is going to have the biggest impact on the trial. I mean, this
This is a
particular
reversible type ruling. If she excludes this, this is something that could get the entire thing reversed on appeal. Unlike we said earlier, if she doesn't let the sketch in, the appellate court's not reversing, a conviction for something like that. But they could very well reverse it for something like this.
It goes to the heart of their case. I mean, their primary piece of evidence is the unspent casing. So to not be able to challenge the methodology and the science of it with somebody who's clearly qualified, I mean, the guy was a Fed forever. I mean, they don't like him. Obviously, the state doesn't because he's running around in all the courts in the country, saying that this is junk science, that tool markings is junk science as they're currently using it. He's saying that I think that there's a way to make it where it's not, but as it's currently situated, it is. So and I think that the jury absolutely has to hear that, and then it goes to weight, like we kept talking about. Goes to weight.
And he
Period.
also made the point, he said, this is like the way the state said that sketch artist, the sketch is a tool. It's not an identification. We need an expert to explain this to the jury so they know tool markings is just an investigative tool, a possible line, something to look at. It by no means, no how, no way is an identification of a gun to a bullet point blank, and that the jury can't know that or determine whether the state's expert was able to really establish that unless they understand how it all works, and that it's important that they know that there is a strong difference across sciences in this field. And even though their expert is going to say this is the end all be all, if the jury is not told that there is a strong, healthy debate and that these things are being challenged, and that some courts, and then so I had mentioned how the judge kind of made a face like she was shocked when he said that there's this healthy debate, and that's been admitted and acknowledged by the head of the, I again didn't take the acronym, babe, but of the entity that both the state's expert and the defense's other expert worked for. And he's like the head of it. And he's acknowledged it, that there is an actual healthy debate as to whether or not it should be admissible in a court of law, period. So then the state got up and they said that these the examples that the state used are outliers. They're Fry and Daubert type rulings, because the defense used some case law from other states, and the state's huge argument was like they're relying on like outliers and issues in Fry and Daubert where you challenge an expert's admissibility, that they shouldn't apply here. And they put into evidence a case that if you listen to our live when we read these motions, where the judge excluded the evidence and said that this could come out on cross-examination, that the defense didn't need to use Tobin to discredit the science and to bring out all of these issues. So then the defense said, if the state's going to give you this one-line opinion from Indiana, how about I give you this Seventh Circuit court where in Illinois, unless it was a state court in Illinois,
It was a state court case.
Okay, state court case where the judge analyzed both sides of the science, broke it all down, and said that this is junk science, and we're not letting it in. And I thought the judge looked surprised, like that she did not realize that there were courts that were starting to say, this can't come in to evidence. They submitted the deposition, and the judge said she was gonna take it under advisement. So that's where they left that. It did seem like initially to me like she was just going through the motions and about to grant the state's motion to exclude Tobin, but at some point I thought I saw a shift, and maybe I'm being overly optimistic, that I thought she actually was paying attention, and I thought maybe she was seeing that there are real issues here and that this is an important expert that the jury absolutely has to hear from. So we'll see what she does, but this would be a huge, huge mistake.
Yeah,
Uh,
I agree, obviously. So that wrapped it. I mean, she took on her advisement, like in terms of when she's going to rule imminently. She obviously we're starting trial tomorrow, and just so you guys have the heads up, motions in limine have been argued. The jury has been selected and sworn in tomorrow, bright and early, 9 a.m. I believe. Opening statements and then witnesses. And I did confirm with Andrea and lawyer Lee, we're going on Saturdays, half days, which is a nightmare, but you know, it is what it is. So that's going to conclude our coverage for tonight. Tomorrow is going to be very challenging for us. I will be in attendance over at the court. However, if you follow us, you know that Allie and I have a prior engagement that we agreed to 7, 8 months ago, where we are traveling to the Berkshires for the Berkshire Podcast Festival with our friend Josh Hallmark. It's his festival with True Crime Bullshit, and a lot of other great pods are going to be out there. At any rate, we're flying out of Indianapolis. We're going to try to figure out if there's any way possible to, because we're about 80 miles out of Indianapolis, where we're situated right now. So obviously, I'm going to have to run from court, get into the car. We're going to have to fly out to the airport and then, park somewhere and then make it to our flight. So we're going to try to figure out, because we want to go live every night. And obviously, we certainly want to talk about openings in the first day of trial. So timing is everything, and it's not working in our favor. It often doesn't for me on that Delphi case. It's like it almost always coincides with something else I had in stone, almost always. Or she does something on Halloween. She being Gull. So stay tuned. We will keep you up to date as to what we're going to do about figuring that out. We love you guys. Just so you guys know what was going on, we've told you we've got benefactors. We have a couple of people that were so incredibly kind to gift us a house for the entire month. And it's just such a gracious act. And I've told you guys, it's they're a really, really sweet couple. And it's Rachel Sticknott and Ryan McGee. They're two avid listeners. And we're so thankful. But their grandparents, Rachel's grandparents, live right across. And while we were in the middle of the live or towards the end of the live, you guys saw the red flashing. I did think I was getting swatted, but we didn't tell anybody where we're staying. So I got up, I saw an ambulance, and I was texting with Rachel. I'm like, oh my God, like which house is your grandmother's, your grandparents? And I looked out, and she's like, it's right across from me. I'm like, oh my God. So I obviously went out there, and then I was trying to keep Allie out of it. I knew she'd come running down too, but
I saw the text. I was hoping, because you and I had thought it was the house over one from there. So I
yeah,
was
no,
hoping
it was them. It's her grandfather has not been feeling well, so they'll keep us posted. Our thoughts are with them. I hope that he's okay. I mean, they're both in their 90s, so it's a scary proposition anytime you get sick. So that's what was going on with that. People were wondering. I was texting Rachel to kind of get updates from her. So, but at lunch, I'm assuming we'll get a lunch break. I'm assuming that we're going to go right into opening statements and then right into witnesses. The state's case in chief will start in earnest tomorrow. She has said that she will go till either 5 or 6, depending on kind of the flow. So if there's a lunch break, I will definitely tweet. So if you haven't followed our Twitter account, I'm defense_diaries. I've got a pretty active Twitter account. Allie, what's your Twitter?
I mean, I'm the opposite of active. I think it's Ali Mata, but I don't know.
Wow.
My phone's dead.
Okay. So just follow
But I
mine.
wanna, like, thank a couple of people. It's like, and now I'm kinda worried about what's happening with their family, but I felt like we should have thanked the super sticker people.
Yeah,
Um,
definitely.
so thank you, Multi-Brad 777, DBA Acid with Elder, and thank you, Jennifer. We appreciate it. And Cindy, I can't, what, how do you say that last?
Uh, Redenius, maybe? I don't know.
Well, thank you very much.
Redenia?
Um, and the people who gave eyewitnesses, there were several, and apparently there were several other sketches. Only the two that were always, the the two that are
Yeah,
usually
Carbal and Betsy Blair, and then the 4 girls on the bridge, the teenage girls that all gave varying, accounts of the person they saw. None of them matched. But again, that just kinda goes to, you're not committing. You don't think that you need to remember what this person looked like. It was just a
right, but
dude
it's
in a
not
fedora.
helpful when they show them the picture of the
Yeah,
video of
that
Bridge
helps.
Guy and then
That
say,
helps a
now
lot. That helps a lot. In terms of, or it forms an impression in your mind, and obviously you're going to harken back to that. So, Afton, thank you very much for the DD podcast memberships gifted out. Jen came in hot early with 20 always givers. All of you, we appreciate you. Every little bit we feel and we love, so we're very, very thankful to you guys when you're kind enough to send us some dough. And remember, we love Venmo. Venmo is the best. Venmo doesn't take a cut. So
oh, thanks,
we
Barry. Lunch on her tomorrow.
oh, thank you. Oh, which speaking of Venmo, I got a Venmo today, which I want to make sure that I shout out real quickly. And it was for lunch today. So that's what reminded it's thankfully let's see, it was Ann Piccolo. She's a ride or die. She gifted us 25 on Venmo for lunch. So thank you, Ann, if you're in
Thank
here
you
or
very
if
much.
you're on replay crew. All right, guys, we love you guys. We thank you so much for hanging with us. Please remember to share, like, subscribe. We're less than 200 away from breaking 25,000. That's like obviously a nice number that we would love to break sooner rather than later. So spread the word. If you like what you hear and what you see, let other people know. We think that we bring
And
you pretty good content. I put a lot of work in this. I'm not just sitting in my bedroom. I'm a boots on the ground guy, and we happen to know quite a bit about what we're talking about. So we hope that you guys find value in it, and we hope that you let others know about us because
I'm
we
gonna
have the
stay
best
back.
cat in the land.
I was gonna say I'm staying back tomorrow and covering Boone while you're at court. So I'll be with you guys
Boom,
in the morning.
boom.
Just me. So
Cindy,
take it
I'm
easy on
kind
me.
to everybody, even to those people that aren't kind to me. I'm always kind to people. I'm
Who's
never.
Tom W?
I don't know, but I'll be kind to them. Doesn't even matter. I'm kind. I'm just I'm a
He
kind
is, he's
person.
overly kind.
So that's it. We love you guys because without you guys, I would just be an old man.
With boots all over the town.
Woo! Talk to you tomorrow.